Welcome aboard, applicants. Let's finish our general bar review, part 3. Okay, now coming down to corporation, agency, and partnership, let's first talk about corporations. I know, so first we'll talk about corporation, then we'll talk about agency, and then we'll talk about partnerships. Okay, now under corporations, thank you for your patience. We're going to be talking about, let's see here, there we go. Oh, alrighty. We're going to be talking about formation, corporation formation of the corporation. Oh, let me see. Trying to get this just like that, and then there we go. Oh. That should come in here. Thank you for your patience with me on this. Okay, there we go. Now, under formation of the corporation, we're going to be talking about de jure corporation. Talk about de facto corporations and estoppel corporations, and then promoter liability. Now, after establishing that there's been a corporation that's been formed, we're now going to be looking into corporate management under the board of directors and the officers. Now, these parties have rights and they have duties we want to make sure to talk about. Now, after that, we're going to be talking about shareholders. Shareholders have rights, and certain shareholders have duties as well. We're talking about the controlling shareholders, mainly have those that 10% or more of the ownership of the corporation have the duty of loyalty, the duty of care. And remember, though, concerning the rights, there's the right to inspect records, the right to demand a dividend, and the right to hold meetings. And don't forget about when you're holding meetings as well, you're talking about quorum. Okay, now, after that, we're going to be talking about federal securities law. Under federal security law, we're going to be talking primarily about two things: 10b-5, insider trading, and we're also going to be talking about 16b, short swing trading, short swing profit, excuse me. And we're going to be talking about these in the context of misrepresentation. Or excuse me, I should say we're going to be talking about the inside trading in terms of the aspect of misrepresentation. Throw that in there just like that. Short swing profit. And after we talk about federal security laws now, and then we are going to talk about, if applicable, Sarbanes-Oxley, and that for reporting. And then after federal security laws have been talked about, we're going to be talking now about fundamental changes. And this would be like mergers, this would be acquisitions, this would be things like dissolution, winding up, those kind of things. We're going to throw that in there. Dissolution, dissociation, and winding up. Okay. Okay, now after talking about corporations, we're going to be talking about agency. Under agency, we have four primary things. We got a creation of the agency. So there's creation through agreement, benefit, and control. Now, under authority, we have three types of authority. We've got actual express authority, actual implied authority, and implied authority. I'm sorry. Yeah. So and then yeah. So we've got actual express authority, actual implied authority, and we have, yes, that's that one. Just double checking real quick that I'm on the right track on that. Yep, okay. And I'll put an asterisk there just to double check later. Okay, now after that we're talking about rights. We're talking about the rights and duties. And we're talking about termination. And termination, things like the parties, the agreement is no longer in existence. We're also talking about the purpose for the agreement is no longer in existence, or the parties have basically parted ways and they're no longer in the agency relationship anymore. Like we're talking about things primarily dealing with joint and several well, let's see, we're talking about respondeat superior primarily. So, and then also put an asterisk here so we can come back and fill that in. Now, in partnerships, we're going to be dealing with three R's. We got the general partnerships, we got the limited partnerships, we got the limited liability partnerships, we got the limited liability companies. And when we're dealing with general partnerships, we're going to be dealing with formation, partnership assets, which this would be primarily titled and untitled assets. We're talking about rights of the partners to manage and control the partnership. And also we're going to be talking about the duties and liabilities of the partners to not only other partners in the partnership, but the third parties who are dealing with the partnership. And then we're going to be talking about dissociation, dissolution, and winding up. And this is pretty much repeated in limited partnerships, except for the fact that there's no third party aspect. We're just dealing with the duties and possibly liabilities of the limited partner, and that would be very limited unless they're directly managing and controlling the partnership. Now, under the limited liability partnership, basically we're following the same idea, formation. We're talking about the assets, rights, and duties, and same thing for the limited liability company, except for special aspects concerning filing of the corporation's purpose, the articles of incorporation with the Secretary of State, and following certain statutory procedures. Now that's corporation, agency, and partnership in a nutshell, and we'll come back later to tackle more of that in detail, but that's for right now. Okay, now under remedies, we have legal damages, we have legal restitution, equitable restitution, equitable, and don't forget about injunction. Now legal damages, this is where we're going to talk about tort. In tort, we're going to be mainly talking about like compensation. We're going to be talking about nominal, or punitive, I should say, punitive and nominal. Remember, we're dealing with compensation. We have some of the limiting factors that we have. We have unavoidable cost. We've got foreseeability. Let's see. There we go. Excuse me. Let me bring that out. We've got certainty, foreseeability, causation, and unavoidable cost. And then punitive damages, we're mainly establishing whether or not there's willful and wanton misconduct. Okay, and then nominal. Now, excuse me. Thank you for your patience. Now, underneath contracts, we're going to be talking about expectation damages. We're going to be talking about reliance damages. We're going to be talking about incidental damages. After that, we will be talking about possibly consequential damages. Special damages would be a form of that as well. And then we would be talking also about nominal damages. And remember, contract law does not get punitive damages, so keep that in mind. And then we have the UCC provisions, so let me throw that in there. UCC provisions for buyer and seller situations, where the buyer's at breach, the seller's at breach, and the buyer's still holding the goods, or the seller has the goods. So all of those different configurations would produce things like cover. contract market differential, loss volume seller, full contract price, and I believe that would round out the list there. Now we talk about legal restitution. We're going to be talking about primarily under tort. We would be talking about money damages. We would be talking about replevin and ejectment. Under contract law, we'll be talking about quasi-contract, replevin, and ejectment. Oh, let me throw that. There we go. Under equitable restitution, under torts, we would be talking about constructive trust and equitable lien. Both of those would have a very similar element list, which we're going to talk about here. Wrongful act, legal title, and tracing that legal title, or the title could be traced, the property could be traced, that is. We're talking about inadequate legal remedies and the priority of aspects concerning the plaintiff, the third party, and a unsecured third party, or unsecured creditor, excuse me. And then now that would be for torts. For contracts, we would have rescission and restitution. Rescission meaning that the contract would be undone. Reformation with the contract would be redone. Okay. Now, due to the aspects concerning fraud, misrepresentation, duress, or mistake. Okay. Now, under equitable, this is where it gets really interesting. We have tort equity, where we're going to be talking about TROs, temporary restraining orders, preliminary injunctions, and permanent injunctions, we'll just do that. Under the temporary restraining order and the preliminary injunction, they share the same element list, which is going to be the irreparable harm, likelihood of success on the merits, inadequate legal remedy, balancing of interests, and defenses. The defenses being latches, unclean hands, possibly the bona fide purchaser aspect, and potentially I think those would be it. Okay, now underneath injunction, we would have inadequate legal remedies, property interest, feasibility of enforcement, balancing of interests, and then defenses. Same type of defenses, by the way. Now, underneath contract, we're going to have here we would have specific performance, and this is where we would talk about the contract being valid, the conditions being satisfied, the terms having been certain and definite, inadequate legal remedies, and we would talk about mutuality of enforcement, or mutuality of obligation, feasibility of enforcement, and defenses. The defenses being unclean hands, latches, and bona fide purchaser for value. So valid contract, conditions being satisfied, terms being certain and definite, inadequate legal remedies, mutuality of obligations, feasibility of enforcement, and defenses. And this would also track too with injunctions here, just so that we would follow up on this. So I just put a little asterisk here just as a reinforcement, not to forget in any one of these torts or contracts that we're dealing with an injunction. So, all right, we could potentially deal with an injunction. So, now after that, we're going to come down and talk about wills and trusts now. In terms of wills, we're going to talk about validity of the will, components of the will. This is where we would talk about revival of the will, distribution without our distribution of the will assets, intestate distribution, which is where we would probably talk about more like per stirpes and per capita, and those types of things are just yeah, there we go. And then also rescission, or sorry, excuse me, sorry, revocation and dependent relative revocation, and then contracts concerning a will. So up here under validity of the will, we would be talking about like the mental aspect, the physical aspect of the testator. So that this would be more like competency and mental mental capacity of the testator to form the will, in that they understand that what they're doing is is creating a will. They understand that the will effectively, distribute their estate, and they understand the nature of their bounty, which is, in other words, that they have a relationship with the party receiving the inheritance. Also, we want to talk about the formalities of the will, the witnesses aspect, as to signatures and witnessing the testator sign the legal document, i.e. the will. And then we're talking also now about something of holographic wills that might pop up here if the jurisdiction has the aspect of recognizing holographic wills as being valid. Under components, we would have integration, integrated aspects, incorporation. We would have physical acts of independent legal significance. Sorry, this would be acts of independent legal significance, pour over wills, and codicils. So now, under revocation now, we would have physical acts, operation of law. The D would be destruction of the will itself, and then subsequent wills. And under distribution, which is where we would have all of the aspects concerning how a will can be distributed. We're talking about B, meaning that we have, okay, well, let's see, lapse, anti-lapse. Okay, yeah, so this would be lapse, anti-lapse. A would be the you know what, I'm gonna have to come back to this. We'll have to come back to this at a later time. We'll talk about these. Now, under revocation, dependent relative revocation, we're going to be talking about whether the first will or the second will is valid. That's one of the major aspects, and whether or not, if that's the case, does that automatically revive a will that potentially the testator did not want revived, in order for the estate to transfer through the will, through a will document. Okay, so under contracts concerning wills, we would have contracts concerning wills. Those would be like contracts that are talked about inside of a will. So I'll put a little asterisk there so that we'll come back and talk about that later as well. Now this would be just for wills, okay? Now coming down here, we're going to talk about trusts now. So I'll make sure to come up here and point this out to you, I should say. This would be wills. We'll bring this in. Excellent. Oh, let's see here. There we go. Excellent. Okay, now trusts. This is where we're going to have the creation of the trust, type of trust, trust management. Oh, let's talk about that. Oh, let's talk about trust management. Oh, there we go. Modification, termination of the trust, and distribution. Creation of the trust is where we're going to have and that's where we're going to have the purpose, the intent, the the intent, the res, the trustee, and I'm gonna have to the an appointed beneficiary or an act, a ascertainable beneficiary. So that would be under creation of the trust, and then now type of trust. These are all the sorts of types of trust that we potentially could have. We got like support. We got support trust or spendthrift trust, support trust, discretionary trust. We have blended trusts. We've got Taunton trust, constructive trust, resulting trust, and we'll have to come back to this as well later, and we'll fill out this. And then now we're going to be trust management. Oh, there we go. This is where we got duties and responsibilities of the trustee. And this is where we would bring up the, okay, here we go. So we got the main aspects concerning trust management, concerning the duties of the trustee, would be segregation of the trust assets, accounting, investments, and diversification of trust assets. The responsibility would be as to protecting the trust res, and defending it. So those two would be tied together, obviously. Now the other one would be management or modification and termination, and then the distribution of the trust assets according to the to the trust document. Now that would be according to trust here, and then now under number actually probably should say number 3 here, because there we go. And then I think that's it for wills, trusts, and estates. We will come back to this, so I'm going to put a little asterisk here up top, and we'll be able to parse this out a little bit better. So thank you for your patience on this one with me. Now, community property. We're going to talk about relationship status, and this is where we would talk about the traditional marriage. This traditional marriage, and this would be the cohabitator relationships, or the Marvin v. Marvin relationships. So I'll just do and then we've got putative spouses here. Okay, so now underneath that'd be the relationship status. After that, now we're going to be talking about classification of the trust asset. Oh, sorry, classification. Excuse me, of the property. And underneath that, we would be talking about the type of asset we're dealing with. And there's only 4, if I'm correct: community property, separate property, quasi-community property, and quasi-marital property. And then now this would be actions taken by the parties to affect the classification of the property. And so we would talk about separation, permanent separation. We would talk about improvements. We would talk about Pereira Van Camp. We would talk about transmutations, gifts, and commingling of commingling of community and separate property assets. And remember, we talked about tracing in those instances, exhaustion of the family expense presumption versus the direct tracing aspect. Okay. Now after that, we would talk about presumptions, and these would be like the marriage woman special presumption, title, the joint title presumption, and then after that we would have priority rights, and that would be where we're talking about creditors, our debts, and we would talk about management and control of the community estate, and then we would also be talking about the third-party transfers, and I believe that's it. And then after that, we would distribute. And remember, ordinarily it would be 1/2, but remember 1/2, or we have the the special quasi community property situations where the property in question is in the name of the decedent or in the surviving spouse's name will affect whether or not the surviving spouse gets one half or the entire property. And then also we want to talk about the separate property of the decedent when we're dealing with things like again one half for one sibling, or excuse me, one issue of the decedent versus one third if there's more than one issue plus the surviving spouse. So of the separate property, remember of the decedent. Now that would represent community property in a nutshell there. Okay, and then under professional responsibility, wrapping this up, we would have, let's talk about duty of loyalty, conflicts of interest. We would have, after that, we would have impugning disqualification. And underneath conflicts of interest, we will come back to this as well. We have like concurrent conflicts of interest versus things like business transactions with a client. We would talk about third party payee situations. We would have we'll come back to that though. So I'll put a little asterisk there. And then down here after that, duty. Oh, thank you for your patience. Oh, there we go. Duty to communicate, scope of representation. That's where the client gets to have the client gets to decide concerning situations about like settlements, whether or not to plead guilty or not guilty, whether or not to whether or not to go to take the witness stand, and then we'll go through that as well when we come back here and fill out some more of the professional responsibility. Let me take this to the next page here. Now after that, we're going to be talking about the attorney-client relationship, or the attorney-client privilege, duty of confidentiality, fees. We're also going to be talking now about duty of diligence, duty of competence / care, and we're talking about zealous representation. Also, where we want to make sure that we're bringing up after zealous representation that we're dealing with a safekeeping client property. So client property, and we want to make sure to safekeep that. Okay, now after that we're going to talk about relationship with the client. That's where the California ABA distinction, and we're also going to be talking about withdrawal, mandatory versus permissive withdrawal, and what are the duties to the client upon permissive withdrawal. After that, we're going to be talking about advertisement solicitation. After advertisement solicitation, we're going to be talking about the unauthorized practice of law, liability for others, and then we're also going to be talking about, we're going to be talking about duty to report misconduct, and we're also going to be talking about duty of fairness, and then we're going to be talking about after that we would be talking about, see here, send my acronym up here. Oh, that's right. One last one. Duty to public / profession. Okay. And we're going to be filling this out at a later date too. So all these are going to receive their own acronym systems with possibly elements to fill them in. Like for instance, this one has advertisements and I'm sorry, let me put this in here. Concerning advertisement solicitation, no direct solicitation. We're talking about supervisor actually liability concerning. Yeah, well, I'll pull an asterisk here because we'll come back and fill that in later, just like I said. Okay, so I think this is pretty good. I appreciate you for sticking with me through all this. We are going to be coming back, so there's going to be like a round two of this. So just look forward to that. And this is where I'll put a little bookmark. And so I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher. I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Again, thank you so much for tuning in.